Morning. This is the time set for oral argument in Harold Grease et al. Versus Plaza del Rio Management Corporation et al. Our case number CV130091. Each side is allocated 20 minutes for argument. We've received the motion for procedural order, granted that, so we'll have a 4-step instead of a 3-step as is typical. I will defer to you on how you're going to allocate your time, and I hope with the sign-in sheet I'll be able to recognize individuals by name. But please do, you'll need to keep track of your time. There is of course, a clock at the podium as you allocate if you wish to reserve some of your time. For those in attendance, please, out of respect for counsel, make sure your cell phones are turned off or turned to mute so that we're not interrupted. We have reviewed the briefs. We've conferenced the case this morning. We encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted to YouTube in due course. Accordingly, as you begin your argument, please state your name and the party you represent. With that, and I'm guessing a bit, but Mr. Royal.
My name is Rob Royal of Tiffany and Bosco, representing Appellants Grease, as well as Eileen Gilbride, in assistance with me as well. May it please the court and counsel, I want to begin by noting that when the trial court judge saw that 2 key shareholders and the only representatives of the shareholders had reached an agreement to alter their distributions with respect to their stock ownership from 50-50 to 90-10, he correctly ruled under Arizona statute that that was a shareholders agreement, and that was a shareholders agreement that expired.
All I see as far as the agreement is in corporate minutes. Is that correct?
No, it's not correct. The record is replete with testimony from Mr. Grease and Mrs. Harper that they had met in advance, they had discussed the issue, and that they had reached the agreement ahead of time. And in fact, they're using the board of directors meeting to then document that agreement.
So the only documentation of the agreement, though, is in the minutes.
Yeah, I believe that.
Written.
I believe that is the only place where it's has gone down into writing. Besides the testimony of the 2 parties and also another person that assisted them in making that agreement. And that's kind of maybe a form over substance, but this is a substantive shareholder agreement that after 10 years expired. And when that happened, it triggered this overpayment issue.
Counsel, let me ask you, the shareholder agreement expired in your view because of a statutory provision, correct?
That's right.
And to get the either benefit or burden of that, the shareholder agreement would have to comply with the statute fully, correct?
Yes, it would.
And is it your position that what is referred to as the shareholder agreement that appears in the minutes or the bylaws does fully comply?
Yes, I think it does for the following reasons. In particular, the statute does allow that all shareholders should sign the agreement, and the minutes do specifically reference the fact that after a vote of all shareholders of the corporation, and then the minutes do get signed by those same people. And besides that, these are the only 2 representatives there ever have been for these entities, and they're the only ones that ever received distributions. It's
signed those corporate officers, would you agree? As opposed to as shareholders? And,
that's right.
And there were some other affiliated entities that existed at that time and presently, right?
That's correct.
And they're not express signatories, is that fair?
No, they are not express signatories, but their representatives are signatories, and they're the 2 people that met and discussed the situation, and their intention was clearly set forth. The Arizona statute on shareholder agreements 10-732 very clearly talks about the kinds of things that you can put in, and it's not a limitation, but one of the main things you can put in is an agreement to change how you distribute, something different than, in this case, the 50-50 ownership, moving it into 90-10, which is what they consented to do. And that's kind of what led to the dispute that later led to the litigation.
They didn't change the ownership, they just changed employment parameters.
Yes, they did, and that actually...
And distribution of profits, right?
Yes.
And the distribution of profits, I wanted to ask, was always done, I assume, according to the evidence, by salary.
I do not agree with that. I think that...
Done by dividend?
No, it's not done by dividends. I think the right word I've always used is distributions, because it technically wasn't a dividend. I don't think it was even reported technically as a dividend.
That would have different tax consequences for, I guess, both the corporation as well as perhaps the recipients.
That's why companies don't call them dividends in privately held.
What's the difference between a distribution and salary?
That's a good question. A salary is a reasonable expectation and a value that's reasonable and associated with the type of work that's being done. The more common scenario is salary plus bonus, so that the rewards of your good work come out in a bonus, which could be another word for this situation, which is deductible to the company just like a distribution is.
I mean, but a bonus ordinarily is salary. It may not be required under, if there's some agreement that employee A will get, say, just to pick a figure, $200,000 a year. Mm-hmm. But if that employee is entitled to more, it's essentially a salary legally, isn't it?
If you actually turn to our wage statute, you'll see that there's quite a broad definition of what wages are, and includes not only salary but also includes bonus and other compensation that goes. I think getting hung up on the technical term, is something that is probably not the right thing to do here because of the way private companies work.
Yeah.
Yeah.
Well, I just wanted to understand it. My understanding of wages and salary is the same as what you just said. I was trying to understand if this was different.
Well, I do believe that distribution is the correct word because they did not use, nor would they ever use the terminology dividends because of primarily the tax situation.
Right.
But everybody's entitled to their fair salary, and in this case, the owners reward themselves from the success of the business if they have it. So once a shareholder agreement, was found by the judge, then that triggered this overpayment issue, because the time the agreement expired in 2010 through 2012, Mrs. Harper took 90% in those distributions, when now after the agreement expired, it should have been 50-50.
Well, according to what?
According to their now stock ownership,
well,
because once the agreement...
Are you telling me that if two people own a corporation 50-50, that means that's how they have to divide any profits?
Unless they have an agreement otherwise, yes. That is correct. The agreement here expired. They just changed it up to 90-10 and it expired. So we're now back to taking their salaries and there's a distribution based on ownership. And Mr. Grease wasn't as active at that time in the business as Mrs. Harper.
I mean, to me, to say that this is one of the things I'm having a little trouble about on I guess your side of the case, and that is that it isn't just obvious to me that the distribution of the 90-10 would revert back to 50-50, because Mr. Grease is, as you just said, he's retired. I gather he may have been going in some, but he wasn't there working full time as he was when it was 50-50. So why would you necessarily go back to that? I'm not sure I follow.
Well, I don't think there's any law that says otherwise to begin with. And when you examine what is a fair salary, which does get attacked in litigations, with some regularity in business disputes, then you're going to examine what is the rewards, what is the profit, should be given to the owners of the company, and particularly Dr. Grease, who started this entity, and Mrs. Harper joined in, and Dr. Grease really was the key person for years until he wanted to slow down a little bit, which led to that 1990 Board of Directors meeting. But then when things got to be challenging for the company, in Dr. Grease's view, he wanted to get back in, which created our deadlock leading to the judicial dissolution when he said, hey, Mrs. Harper, let's change this back to 50-50. She said, nope, we're not going to do that, and thus our breach of fiduciary duty claim, which is the overpayment. That's our damage theory. And so the timing, I think, is quite important. You're looking at damages from 2010 through 2012 that should have been paid because of proper distributions by the duties set up, by company officers and directors, and duties owed between members of companies to each other. And so this all was, well and good until the Judge Brain at the underlying level said, hold on a minute, now that we have in late 2012 a shareholder agreement, that changes. I'm going to take away the damages I already awarded you.
Well, Counsel, I have a couple of questions about that. When they had the fair value hearing before the execution of the shotgun provision, the judge rolled in to the valuation of the company the value of your client's claims, and coming to the value. And it looks to me that with the shotgun agreement, that the value of the claims that your client has also got rolled into that, because the value of the 1.5 million seems roughly equal to your client's valuation of the company plus the damages. Am I now perceiving that correctly?
No, I think you are perceiving that correctly. And it's a question of, is it, a substance or form or a matter of convenience? Certainly the issues were pending at the same time, so we had to deal with it, particularly by the time the judgment rolled around in January 2013. So certainly there was that matter of convenience. But, of particular interest here is that this valuation statute, that kind of got to that point in your question, Judge Howe, is, it doesn't deal with the situation of what if there's a contract, what if there's a buy-sell, what if there's a shotgun buy-sell, which Judge Brain picked up on appropriately. So while, the statute coexists in our case with the contract, the legislature, as Judge Brain said, didn't take that into consideration. And interestingly, the contract itself, the shotgun buy-sell, didn't take into account what to do in light of that statute. Now, the statute did come in after the contract, but that does raise the question, well, the parties didn't change anything.
Well, if we were to hold that the buy-sell agreement of 1.5 million is fine, and then your client also has the damages claims remaining, and there seems to be a risk of double recovery, which is something that concerns me, because it, as I said in my earlier question, it appears that the 1.5 million includes the damages, and if that's the case, then your client would have this cake and eat it too, it seems.
Well, I don't agree with that, because they are independent. One stands alone from the other. You can't even use a but-for test to tie them together, because one arises from the shareholder agreement, and that is our damage claim. But for the ruling in the shareholder agreement, we wouldn't have that damage claim. So that's where an example of your but-for test. But that doesn't tie to the stock value at all.
But it seems to me that Ms. Harper's counsel, at least in going forward with the shotgun agreement, presumed or at least indicated that by executing the shotgun agreement, that they would move to dismiss their claims because of the executed shotgun agreement. And I understand that you may disagree with that, but at least that's her view of that, correct?
That is her view. We certainly, disagree with it because of how the two do not tie together, and one can exist with the other without the other. And the separation is clear both by the pleading and by the determinations, I think, of Judge Brain, and when he did have to pull these issues together and make his judgment. So this is clearly a situation that, to me, and I think when you examine this, that exists showing and demonstrating, the separation that one doesn't tie to the other. I'd like to move on at this juncture and make a couple points before I reserve some time. which kind of goes to your question as well, Judge Howe, because once this damage thing from 2010 through 2012 reaches this point where the court's going to allow the freedom of contract and the parties to exercise their rights, exercising rights that either party could take in at any time. I mean, Mrs. Harper had the right to choose, I'll go with a shotgun buy-sell, or I'll go with a buyout in response to the judicial dissolution, and she made her choice. And then Mrs. Harper again had a choice a little bit later on when the shotgun buy-sell came out. I can accept a value of 1.5 that's about 10 times what the judge and my expert said it was, or I can buy out, Dr. Grease for about half of what his expert said. So the playing field was level here, and she made her choice. We've got two sophisticated, experienced business partners and business persons who practically had tools at their behest to make the careful choices they wanted to make with respect to how they're going to handle the situation between them. And I think they both exercised those rights, including, Mrs. Harper, in what she decided to do that really didn't tie to those damages at all.
So the fact that your client's value of the company plus the damages is roughly equal to 1 per million is just coincidence?
I missed your question on you mean the 1.5 million?
Yes.
Coincidence to what?
The 1.5 million that the parties agreed to just happens to be a similar amount to the combination of your client's valuation of the company plus the value of the damages that your client is claiming.
Frankly, I've never thought of that, but our damages with our motion for reconsideration are about $800,000. Mm-hmm. That was, less than the 200 or more than the 200,000 given to us by Judge Brain in his order. And so I don't think that quite approaches that middle number of 1.5 million. That's kind of, at the low end of their 157, the high end of ours at 3.3. So with that, I'd like to reserve some more time for things later. Thank you.
Thank you. Mr. Schenk.
Good morning. My name is Joe Schenk of the Aiken Schenk Law Firm, and I'm being assisted today by Tom Zlackett. We represent the Appellees cross appellants that have been collectively referred to in this case as the Harper parties. And while we have raised what I believe are a number of meritorious arguments against the appeal filed by the Grease parties, I'd like to focus my comments today on only one, and that is the trial court's misapplication of ARS Section 10-732. First of all, let's talk about what 732 is conceptually and what it is not. What it is it's a very special type of shareholder agreement that has very strictly spelled out criteria as to what is or is not this special type of shareholder agreement.
Covers a lot of ground.
But it doesn't cover all the ground, because if you look at ARS 10-732H, which I think is very instructive, subsection H states that this section does not apply to agreements that are otherwise valid or authorized without regard to this section, including without limitation shareholder agreements between or among some or all the shareholders. It goes on, the same subsection, to state the procedure set forth in this section is not the exclusive method of agreement among shareholders with respect to any of the matters described in this section. So it is very clear that the mere fact that two shareholders happen to reach an agreement, decide they want to go to a hamburger joint for lunch, does not elevate that into a 732 shareholder agreement. And that's really critical here, because what has happened is the Grease parties were able to persuade the trial court that a board resolution acted upon during a regularly scheduled board meeting, documented as minutes of the board meeting, signed by just two people acting in their corporate capacity, Sharon Harper as corporate secretary and Harold Grease as chairman of the board, constitutes or complies with the requirements of 732B to be a, what I will call this special type of expiring shareholder agreement.
Counsel, so do you concede or agree that a shareholder agreement could cover this type of agreement? So it could fall under A, but it fails under B?
That is correct. It could. The subject matter clearly is something that could have been handled in a shareholder agreement, a 732 shareholder agreement, but that doesn't mean that it was handled. And in fact,
let me make sure I understand what you're saying, please. Are you suggesting to us we don't need to spend much time thinking about whether this comes within, say, 732A2?
you really don't.
Because it doesn't matter for some other reasons you're going to argue?
That's true. Because, first of all, let's talk about the requirement that it be signed by all shareholders. And that's true. It's either got to be agreed by all shareholders or signed by all shareholders under subsection B, correct?
Well,
and so,
I think so.
Given that, look at the document that they're relying on. It is a board resolution, and it is signed by two people that happen to be two of four shareholders. There were actually four shareholders in this company, not just Harold Grease and Sharon Harper. There was also the Grease Family Limited Partnership and the Harper Family Limited Partnership.
And so who controls those entities?
Well, I could tell you, but it's not in the record, and I don't think it's before you. And the fact of the matter is, we have a better frame of reference as to what needed to be done in order to do a proper shareholder agreement under Section 10-732, and that was attached as Appendix B to our response brief. In 1985, the parties to this litigation signed a document entitled Stockholders Agreement. And if you look at it,
We have.
and if you look at it, you'll see that it was signed not by just Sharon Harper and Harold Grease in their individual capacity. First of all, it's defined as being signed by a list of shareholders, and it includes not just Dr. Grease and Mrs. Harper, it includes the signatures for the other two shareholders. So they, in fact, knew from prior practice how to create a valid shareholder agreement under Section 732. You call it a shareholder agreement, you sign it in your capacity as a shareholder, not as an officer or a director, and you have all four shareholders sign it.
But aren't we pretty close here, even though we don't have a signature of all four shareholders? But the 732B 1B says an agreement authorized by this section shall be, and then it says in a written agreement that is signed by all persons who are shareholders at the time.
And this does not comply. First of all,
hold on, let me finish my question, please. Because in the board of directors minutes, and Mr. Royal made a reference to this, it says present were Harold and Sharon representing all of the voting shareholders and directors of the corporation. So it says in the second paragraph on the first page, here are the people who are present, and this is their capacity, representing all of the shareholders and directors of the corporation. And then they sign at the end. Why? I realize it doesn't meet the tidy standard of the 1985 agreement, but isn't that awfully close?
No, it's not, and I'll tell you why. Because if you look at, again, the special meeting minutes that you were just referring to,
yes.
The first page down to the third line from the bottom is, in fact, a shareholders agreement, and the language that you were referring to about who they're there on behalf of is in that part of the document.
I would submit that might be there might be minutes of a shareholders meeting. I don't know if it's a shareholders agreement.
Okay. But in any event, the meeting is specifically a shareholders meeting through
until
a third line from the bottom on the page.
To the board of directors meeting.
Right, and then you have a heading, the chairman, and that, by the way, is Harold Grease.
Yep.
Announced that the remainder of the meeting would be a meeting of the newly constituted, or the new constituted board of directors. Yeah, so all the language that we're here discussing in this appeal appears on the second page after that language. So they clearly denominated, all right, we had a shareholders meeting. Now the same people are here, but we're going to go forward, and now we're having a board of directors meeting.
Are you arguing that these minutes are not a shareholders agreement under the statute because it's not properly signed, or because it simply isn't a shareholders agreement?
I'm arguing both. I clearly argue both in the briefs, and I argue today that this was not a shareholders agreement. It was a decision made by a unanimous vote of the Plaza del Rio Board of Directors. That's what's reflected in this document. It's not reflected. There's nowhere described in this document that this was an agreement between shareholders as opposed to being an agreement between directors. And that's what I was getting into when I earlier mentioned subsection H of the statute, because shareholders can have multiple capacities. I can be an employee. I can have an agreement in my capacity as an employee. I can be a corporate officer, and I can have an agreement as a corporate officer, or I can be a director and can have an agreement with other directors as a board, as a member of the board.
But when the shareholders and the directors and the officers are all pretty much as two people, how much attention has to be paid to all of the niceties that we as lawyers would like to normally see?
Well, let's look at this. The fact of the matter is, the only issue as to why we're discussing whether this is a 732 agreement is the fact that those special type of shareholder agreements expire after 10 years if you don't specifically state otherwise. This was an agreement or a reallocation of compensation that was made, that was precipitated by Dr. Grease's announcement he's going to retire as an employee, and he's no longer going to be working to earn any money through this company. And so a decision was to adjust compensation to reflect the fact that Sharon Harper is going to continue to work on a full-time basis, and Dr. Grease is going to sit back and clip his coupons.
Or whatever.
Or whatever.
Yeah, but counsel, I understand the consequence, or correct me if I don't understand it correctly. The consequence of your argument is that Dr. Grease's claims go away because there's no factual underpinning for them, but I'm concerned about further down the road from that. We have a shareholders agreement, and what effect does the argument have on the validity of the shareholders agreement?
Well, I think we have a different argument as to why the shotgun buy-sell agreement is not valid, because it was basically forced upon Sharon Harper based upon what we believe was a completely erroneous application of ARS Section 10-1434. And I'm burning through a lot of my time here, but I do want to just summarize real quickly in the 732 issue. It's actually an easy way to resolve this, because if you think about the context, Dr. Grease is retiring. It was not anticipated that once he retired, 10 years after his retirement, that he's going to come back to work. So there's no contextual reason why the parties would have expected or anticipated that they were entering into an adjustment to compensation that was only going to last 10 years and then it was going to go back to, the prior arrangement. That makes no sense in the context of one of the two employees saying, I'm going to retire. So again, contextually, the idea that somehow the parties knew or understood or anticipated this was a 10-year expiring agreement makes no sense. And if you accept the premise that this was not a 732 shareholder agreement, then all of the issues they raised in their appeal go away, because if this was not a 732 shareholder agreement, then it didn't expire after 10 years. If it didn't expire after 10 years, there was no basis for finding that Sharon Harper was overcompensated. And if there's no basis for finding that Sharon Harper was overcompensated, then there clearly was no error in either refusing to reconsider the amount of the overcompensation or the decision to vacate the interlocutory ruling. I'd now like to get into, and I'm going to probably talk faster than I would normally like, about what we think is the big issue in this case, and it has to do with the application of ARS 10-1434. As courts are aware, that is part of the larger statutory scheme for judicial dissolution. And we think that what happened here was a remarkable example of gamesmanship where, because of the trial court's misinterpretation of the statute, the Greece parties were actually given the opportunity to litigate a disputed lawsuit to a final ruling on the merits by the trial court, decide that they didn't like the outcome of that ruling, and to, in essence, moot it out by invoking a contractual right that they had prior to the time that they ever filed the dissolution lawsuit in the first place.
Under the guise of being equitable, as I understand it, or not,
Under the
perhaps not guise, under the reasoning of being equitable.
And the problem is that was actually part of the misapplication of 1434 by the trial court, because the way the statute is set up, you have, three levels. First of all, you can file a dissolution action, and if the other side hasn't yet made an election to purchase rather than to let the company be dissolved, you have the same rights as you always would to dismiss the lawsuit without prejudice because there's no response yet. And there's no equity at all. That's the first stage. However, once the other shareholders or the company elects the right to purchase the plaintiff's stock rather than allow the company to be dissolved, the statute is fairly clear, actually it's very clear, that at that point you get into a situation where, first of all, the party electing to be a buyer cannot back out of that election unless the court finds it's equitable to the other side. And secondly, the plaintiff filing the lawsuit cannot simply dismiss at that point or sell their stock under another arrangement without the court finding that it would be equitable to the other side to do that.
How do we get that last conclusion that you just stated from the statute?
Because it says in subsection B of 1434, after an election has been filed by the corporation or one or more shareholders, the proceeding under section 10-1430, subsection B, shall not be discontinued or settled, and the petitioning shareholder shall not sell or otherwise dispose of his shares unless the court determines that it would be equitable to the corporation and the shareholders other than the petitioner to permit this discontinuance, settlement, sale, or other disposition. So it's expressed in subsection B. And that's now, we're just at the point where there's been an election to buy, not where there's been any determination of value, because then you get to the next step in the litigation, which is the parties either agree to the fair value of the petitioner's stock, or failing that, they go to court and the court decides the fair value. In this case, that's what happened. The parties didn't agree. They went to court. They spent a ton of money on experts and attorneys, had a 2-day evidentiary trial on this issue, and at the conclusion, the trial court issued a detailed ruling in which he found that the fair value of the Greece party's stock in Plaza del Rio was $157,100, and then he did an add-in for the overcompensation issue. And what we're saying is they got that number, and it wasn't until after they got that number that they ever made any attempt to exercise their rights under the 1985 shotgun buy-sell agreement.
So there's no equitable out once the hearing has occurred?
That's right. The equitable out goes away because, first of all, think of it this way. Whether you want to call it a waiver, estoppel, or claims preclusion, you cannot have a system where parties can file, conditional lawsuits where they're going to pursue it to a final ruling, and if they don't like the court's ruling, they have the right to walk away from it and do something else.
Parties always have a right to go settle, don't they?
Yeah, but this wasn't a settlement. This was invocation of a different remedy, the contractual remedy, and we made a clear objection to that. We fought it, we lost, right. And bottom line was that the trial court said, you've got until this date, and if you don't agree to buy their stock, you're going to have to sell your stock, and that was completely unpalatable to Sharon Harper, who was working for the company and had, relationships with investors and with customers and so forth. So
but what you're really arguing for, if I'm following correctly, is that is the conclusion that once the parties start down the 1034 road, all their prior agreements are,
call it an election of remedies if they're more comfortable with that.
Out the window.
What I'm saying is once you litigate this dissolution proceeding to a final determination of fair value, Under the statute, everything becomes mandatory for the trial court at that point. Subsections E and F don't say the court may go forward and enter an order requiring the sale. It says the court shall go forward. And so it's an administrative, non-discretionary task once the final decision on the merits has been made. And I apologize, but I've only got 2 minutes and 30 seconds I'd like to reserve for my rebuttal.
Very well. Thank you, Counsel. Mr. Rowe. Mr. Rowe, before we proceed, give me just a moment here.
2-3 minutes aside.
Counsel, we're inclined to give you both 3 minutes additional time per side.
I have 3:56.
That would give you 6:56. So
three more. Okay.
Yes. Yes. No, I'm sorry. Not. No, I apologize, Counsel. I did not mean to create an ambiguity. To give an additional 3 minutes per side. So just bear with me for a minute while we fix your clocks, and we'll go from there. And we'll adjust the last clock before we call you up. Mr. Royal, please.
Thank you. The court is, in my view, properly focusing on the equitable language of the statute. That's the out. That's the fail-safe. That's the fallback, that's allowed in the statutory process for these things that come along, just like these contracts, for possibly settlement has been, raised. And so while you have a statutory procedure, Judge Brain was correct in looking at this, unless it's equitable to do otherwise, and that's what he did. That is the purpose of this statute, to really accommodate these kinds of situations. Even the methods of value, when you take a look at under the buy-sell arrangement, which is really a market analysis, supply and demand, negotiation, versus a fair value concept under the statute, these sophisticated business people made their choices. It was a level playing field all along the way. And Mrs. Harper elected to do the buyout under the statute. And when she saw the number that came from her expert, that came from, the court, I'm sure she was very pleased to see it was only $157,000. And there is nothing in that statute that deals with situations involving a contract other than the equitable relief that's there. So Judge Brain took a look at what he had to. He saw that the statute doesn't directly address contracts, and the contract doesn't address the statute, but I got to deal with it. I'm the judge. So he exercised his discretion and said, I'm going to support the right of the parties to contract and move forward and allow what the intent of their parties have been. Because this is an agreement that was in place since 1985 that the parties saw no reason to change or alter along the way, and he decided to proceed forward with that.
I'm seeing a little irony, though, in that with respect to an event in 2000, the Board of Directors meeting, we're not applying freedom of contract, because we're applying instead a statute under one side's argument to cut it off at 10 years.
Well, that's what
I'm looking for a unifying principle here. I'm not finding it.
Well, I'm not sure that you will, because in the particular case of shareholder agreements, the legislature said 10 years is long enough, and then they ought to take a look at these kinds of things. I mean, what more could the parties do? They're the only ones that are really active in the business. They are the ones that are operating the business. They're the ones that really own the business for all practical purposes. They reached an agreement before you ever got to the board meeting. Then they put it into writing, and they lived with that thing for more than 10 years, really, for about 12-something years. They had no incentive to do anything else, whatsoever. The signatures that were good enough on the 1985 stockholders agreement, they delineate and tell you who are the real parties here, and that's what Dr. Grease and Mrs. Harper knew when they reached their agreement, signed off, and lived it with it for 10 years, so that they understood what was going on there. The $1.5 million that was paid for, by Mrs. Harper for Dr. Grease when she elected to be a buyer rather than a seller, this does kind of go back to this idea of, well, is this really a company claim that eventually was pulled together by the judge? And it really isn't. What difference does it make, or would it have made to the company in this situation? The money had been paid out in 2010 and 2011 and part of 2012. It was in the hands of Mrs. Harper, and as Fletcher Cyclopedia of Corporate Law says, we put in our brief, once the dividends or distributions or money's paid out, it's out of the company's till. And unless there's something wrongful, like a wrongful distribution in our statute, which isn't even in play, then you got to go get your remedy. And the remedy for Dr. Grease is, she's got my money, and I really need to get that back.
Look, counsel, so the court was wrong in its value determination to roll in the value of of your client's damage claims then.
What's wrong with it is because he had a loss out of his pocket from 2010 through 2012 because she had money that should have been his. That's separate when you go look at a negotiated arrangement to buy out the stock. Two things.
But you're arguing, if we're looking just narrowly at the trial courts for value determination, that was wrong. Because,
yeah.
Okay.
It's a direct claim that Dr. Grease has. I mean, he couldn't successfully, sue the company. That would have been subject to a motion to dismiss. Really, he's been unjustly enriched because Mrs. Harper had the money that was his. He could replevy the money, for example, or but certainly under a fiduciary duty claim that we brought, which was our damage claim as it came out. That's where we were. If in fact that she ended up with buying out the stock, which she did, and now she's the full owner of the company, is she going to bring a claim against herself to return to the company the money? Well, of course not. That's just not something that's going to happen. She probably bought Dr. Grease's stock so she wouldn't have to, wouldn't have to pay Dr. Grease, at least she thought, and now the judge supported that position. He had already made the ruling when all that came down. Dr. Grease set the price. He is prepared to be a buyer of Mrs. Harper's stock, and he recognized that he would have to be a seller as well. And so while I touched on, the statute done dealing with the contracts and the fairness of the decisions of business people, it wasn't only Mrs. Harper, but it was Dr. Grease that also could make those kinds of decisions. There was no forcing anything here. This was a voluntary choice that could be made. She wasn't forced to go buy Dr. Grease's shares. Dr. Grease, who started this company and was the one that really was the driving force for many years, he had a lot to say about this company and its success. So it was a voluntary choice made by Dr. Grease and also by Mrs. Harper along the way. Thank you very much.
Thank you, Mr.
My time has expired.
Mr. Schenck will add 3 minutes. You can wander up to the podium while that's happening.
Before you start the clock, I would have loved to have had time to ask one or both of you why the statute places this 10-year limit on it, but I didn't figure it was pertinent to our issue, so I didn't want to use up your time, but I don't really understand that.
Very well. Mr. Schenck.
For counsel to suggest that Mrs. Harper's decision to pay $1.5 million for stock that the trial court had previously determined was worth $157,100 was a voluntary choice is a lot like saying that character in The Godfather who was told that he was going to have his signature or his brains on the paper in the next 10 seconds made a voluntary contractual decision. Sharon Harper was faced with a situation where she was not willing to give up her relationship with Plaza del Rio under any circumstances, even on circumstances that made no economic sense, simply because she had spent 30 years of her life building this company. And notwithstanding what counsel said about Dr. Grease's involvement, he had been retired since 2000. The company took off and became successful only after his retirement, and that's in the transcripts and hearing records. The fact of the matter is Sharon Harper felt a lot of loyalty and obligation to the employees and the customers of Plaza del Rio, and she was not willing to take any litigation strategy or any contractual decision that imposed any risk that she would ultimately be ousted from the company.
Is it fair to say she made a business decision? Now, you're saying she had to consider improper factors in making that decision.
She made a decision that was personal to her, based in large part, frankly, on emotion and feelings of loyalty and obligation that no rational financial advisor would ever suggest that she make.
Well, and how is that involuntary, though?
It was involuntary because we had gone through the practice. She was prepared to pay fair market value, whatever it was going to be determined by the court. She was willing to pay the fair market value that was actually determined by the trial court. And after spending the time, effort, and money to litigate that issue to a final ruling, the court failed to follow the strict language of Section 1434 and basically issued an unexpected ruling where she said, notwithstanding the fair value I've already determined, and in fact, I've quoted to you the language the trial court at the hearing where he basically said, well, I just don't think the legislature had the shotgun buy-sell agreements in mind when they enacted this statute. So he kind of made up his own legislative history, if you will, as to this exception that he was applying to enforcing the statute according to its own unambiguous language. Because if you look at subsection E of Section 1434, on determining the fair value of the share, the court shall enter an order directing the purchase on the terms and conditions as the court deems appropriate. So bottom line is, it doesn't say that the court can, or the court typically might, enter an order requiring the sale at the fair value on terms and conditions. It says the court shall enter that order. This court did not enter that order, even though it's undisputed that it had made a determination of fair value.
Could we go back briefly to the equitable out, and forgive me if I've forgotten a portion of all the briefs here today. Does this statute come from somewhere, from a model act or from some other state, and are there cases that tell us what is and what maybe isn't equitable for the equitable out?
The answer is, I believe it comes from a model act. I don't know if there's any case, certainly no Arizona case law that would give any guidance to this court on what's equitable. But again, I think that the equitable issue is frankly a red herring, because if you look at the structure of the statute, it goes on gradients. It says it has no limitation on the petitioner, in this case the Greece parties, dismissing the lawsuit before an election to buy is made. Then, as I previously argued, in subsection B, it says once an election's made, the parties are pretty well stuck with their positions in this case unless the court finds it's equitable to do otherwise. It then goes on and says that the parties or the court should reach a determination of fair value, and then you get down to subsections E and F, and it tells you what happens after the fair value determination is made. And clearly, we had gotten to the fair value determination because they made no effort to do anything other than go forward with the dissolution proceeding in Section 1434 until after they received a final ruling on fair value and were unhappy with the number that the trial court reached.
And your position is that when you get to that fair value point, the parties cannot do anything. They could not resolve it. They could not amicably agree. They're bound by court order and they can do nothing else? That's my position.
What we're calling the equitable out under subsection B is no longer available under your position.
That ship had sailed, Your Honor. They could have done it any time up until that, I think it's August 30th or August 13th order where the fair value determination is made.
And for that argument, you rely solely on the language of the statute. There's no case that you're aware of?
I'm not aware of any case, but again, we've cited a lot of cases that say when you got clear and unambiguous language, you rule according to what the statute says.
And we don't care about any private contractual or arrangements that the parties have previously made?
I think you don't at that point because they made their call. As pointed out, they could have elected to go under the 1985 shotgun buy sell at any time before they filed the lawsuit. They could have even proceeded at that point after the lawsuit was filed but before the election was made, without any determination from the court. It was only after the election was made that they had to worry about equitable considerations preventing him, kind of like under Rule 42A, you can't dismiss a lawsuit.
Counsel, I appreciate that. Your time has expired. Counsel, we appreciate your briefs. All cases we have, candidly, are interesting, and this one is particularly so. We appreciate your oral argument as well. We will take the matter under advisement. We'll issue a ruling in due course. Thank you all. We stand adjourned.